number 33, Somereve versus Plaza Construction. Good afternoon, Counsel.
Good afternoon, Your Honors. My name is Howard Fishman with Rafter & Associates on behalf of the appellant Plaza Construction Corporation. I'd like to reserve 2 minutes for rebuttal, if I may.
Of course, sir.
Sure. Plaza submits that the plaintiff's motion for summary judgment was premature because Plaza demonstrated that further discovery regarding the accident could establish that plaintiff's negligent operation of the prime mover was the sole proximate cause of his injuries.
Counsel, in your papers, did you argue that this wasn't a 240 case in opposing summary judgment, that this case didn't fall within that labor law provision?
In the initial papers before the Supreme Court?
Yeah.
I believe it was argued that the accident could have occurred due to his own negligence, not necessarily sole proximate cause. So if it wasn't a 240 case, then it was just a standard negligence case, and yes, I believe we did argue that.
You did?
Yes.
But you didn't argue that it's not an elevated risk.
Excuse me?
You didn't argue that it's not an elevated risk. Your position,
No, it's
I
not.
thought, was he's the sole proximate cause.
Well, the argument is that it's not an elevated risk because he didn't fall from an elevated height. He fell possibly from an 8-inch platform and basically fell off the prime mover. That's what his testimony was to Mr. Kramer.
But is that the argument that you made? I thought your argument was limited to the sole proximate cause.
And the argument
Which,
was
of course, is a labor law defense. That's why I'm sorry. I thought that, in response to Judge Garcia's question, I thought that this is a labor law action.
It is a labor law action.
I didn't think that you were arguing that it wasn't a labor law case. I just thought you were arguing that you had certain defenses to it.
Yes, well, we're arguing that the motion was premature and that there was additional discovery that was necessary.
Oh, I understand that. I just want to be clear about that you aren't arguing that this is a comparative negligence case.
No, we're not arguing it's comparative negligence. We're arguing that there's a possibility that the plaintiff's admitted negligent operation of the prime mover was the sole proximate cause of his injuries, and that we needed discovery to explore that. Right. That discovery may also reveal that this is not even a labor law case, but we're not there yet because we didn't get that discovery. For example, there could be other reasons for the accident to have occurred other than implication of Section 240.
So on that, let's get a couple of facts clear. Had you actually served subpoenas on any of these other eyewitnesses?
Yes, two subpoenas were served.
A yes or a no, either you served them or you didn't.
2 subpoenas were served on Mr. Catalano and Mr. Caratini. There were additional eyewitnesses which we had yet to identify by full name. There was at least 2 individuals known as Mike. One was Mr. Caratini's partner. There was an individual on the scaffold known as Mike. I don't know if he's talking about the same person or somebody else. There was also plaintiff had testified that there was an individual who gave him hand motions who was also on the scaffold. We don't know who that person is yet either. We had approximately 3 weeks from the time that we conducted our deposition, Mr. Kramer's deposition.
And so they make their motion. That resulted in an automatic stay of discovery.
Correct.
Did anybody go to the trial judge and say, can you lift the stay?
Yes, because we had already served the subpoenas and also already noticed the depositions of Mr. Catalano and Mr. Caratini. Plaintiff had rejected to taking those depositions. We had a conference before Justice Singh's law secretary, and it came back that those depositions or any discovery couldn't proceed because of the stay of discovery pending the motion for summary judgment. So we were precluded from taking those depositions, which were noticed, I believe, for sometime in July or August, based upon the filing of the motion for summary judgment in June of 2013, just 6 or 8 weeks after our deposition in May of 2013.
So in your opposition to summary judgment, did you argue that that he had been provided with a safety device or some kind of safety instructions?
Well, we argued that the prime mover itself is a safety device in that it's a machine that's used to hoist the materials, and it was regularly used at the site to hoist pallets of bricks from the ground and place it on the scaffold.
Well, let's stay with that. Let's say that you're correct, logically. Aren't you required to provide a safety device that operates so as to protect the worker, right?
Yeah. When we're dealing with
You would agree with that proposition?
and the
So
court-
let me finish.
Yes.
You agree with that, though, right?
Yes.
All right, that's your obligation. So if that's the case, can you say that this safety device, this prime mover, operated so as to protect the worker?
Well, the safety device that's provided for something that hoists is to protect the worker from being struck by the item that's being hoisted. When you're standing on a platform that's 8 inches off the ground, it's not a reasonable expectation.
You know, the funny thing is these cases, there's a lot of these cases of forklifts, people being thrown up in the air under forklifts. That's why they were redesigned and changed, the design was changed. Also, bobcats tipping over. These aren't really particularly unusual cases. These accidents do happen. In other words, that they're misoperated and somebody gets hurt as a result of the misoperation.
Correct.
So I think in a case like this, we would assume that the plaintiff might not have operated correctly, probably hit the fork somewhere on the scaffold and it caused the thing to tilt. So it didn't protect him then when it threw him up in the air, right?
Well, that's the question. Did it throw him up and off the air or not? I mean, it's a question of fact whether he was thrown off
Really?
the air, because he told Mr. Kramer, I fell off the machine. I simply fell off the machine. That's what Mr. Kramer relates in his accident report.
But
He
even
just
if he fell off the machine, didn't you have to provide him with a safety device so he wouldn't fall off the machine? I mean, if you're up in the air,
Well, that's-
the potential to fall is always there.
Well,
Isn't that the
that's-
point of the statute?
What's
I
the
had
up in
thought
the
too,
air?
Kramer's EBT seemed pretty consistent in his description of the accident with the plaintiff's description of it.
I don't believe so, because Mr. Kramer gave a number of explanations as to what plaintiff told him.
Well,
how
the reality
accident
is
occurred.
Kramer isn't there. He doesn't see the accident, and everything he has to say is really speculation,
Well-
other than the fact, the only thing he knows is that when he comes to the scene, the machine is upright.
Well, he knows the machine is upright. He knows that the machine did not tilt, because if it tilted, it would needed some other equipment to rewrite it. So we know that the machine did not tilt over. It didn't slam to the ground. So we know that. We
What
know-
is your theory about how you think the plaintiff could have been the sole proximate cause?
We
of
think the
this?
plaintiff could have been the sole proximate cause because he, assuming that he did fall from the machine in the manner he suggests, he could have slammed on the brakes of the machine when he came in contact with the scaffold. The machine may have just tilted slightly when it came in contact with the scaffold if he slammed on the brakes. He may have had the pallet blocking his vision and didn't observe the scaffold itself. He didn't follow the directions of the person on the scaffold that was giving him the hand signals. I mean, there's a variety of reasons of how the accident
Aren't
could have
those all
occurred.
comparative negligence questions, not sole proximate cause questions?
No, because when you have a situation where the lift itself is not defective, the lift operates properly, the
Well,
lift
sole proximate cause usually involves either the refusal to use a safety device or disregarding a supervisor's instructions on a safety device. Let me finish. It falls within one of those two categories. Everything you've described means that he didn't operate the machine correctly, he made a mistake.
Well, if those are the more recent cases dealing with sole proximate cause, but going back to the more historic cases such as Blake, where this court determined that it was a question for the jury to decide, rightly for decide.
It's a funny thing about Blake, both parties quoted in this case.
See, but in Blake, there's no definitive proof that the plaintiff failed to lock the locking mechanism on the ladder. We get to it in sort of reverse fashion. You get to it by finding that the ladder was properly placed. He admitted it was properly placed. He admitted that the ladder was not defective. He just couldn't recall whether or not he had locked the ladder or not. And yet,
But here, that's my point. Here, what's the safety device
Well, the
for
safe-
him not to fall off? How have you provided something to minimize that risk or avoid the risk completely?
well, we submit that there is no safety device required to protect him from a 8-inch elevation by standing on the
Okay,
platform.
But
did
then
you
we're back
submit
to-
anything in opposition to the motion to summary judgment related to that
Well,
response?
that issue wasn't argued below, because the issue that the plaintiff had argued before both the trial court and the First Department was that the lift itself tipped over because it was inadequate to handle the load. The argument that he should have been provided with some sort of seatbelt or whatever, some unidentified safety device, was first raised in the plaintiff's brief in this court. So,
But you didn't say, in opposition to the motion, wait a minute, Judge, this is not a 240 case to begin with.
Well, we argued that there was discovery that was necessary. And so because
No,
once the
but-
case is premature, then a lot of things can happen once the discovery comes out. I don't know what the discovery is going to relay. I just know that the depositions of the eyewitnesses who were on the scaffold itself could relate as to exactly what happened. We don't know what happened. All I know is we have questions of fact all over the place as to what might have happened, because he testifies that he only lifts the scaffold 5 feet, only lifts the pallet 5 feet. The scaffold's 6 feet tall,
All right,
and yet
so
the pallet ends up on...
I just want to be clear about who has control over these various eyewitnesses. Whose employees are they?
Town masonry, they're third parties, they're non-parties.
Okay.
Non-parties.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff respondent. Before I get into my argument, I just wanted to correct a couple of factual statements, and I have record references for you. Judge Fahey, you had asked a question about what Kramer said. Kramer said exactly what the plaintiff said, 345, line 15. I went over to look at the handlebars and piece of machinery to see how he, referring to the plaintiff, said. He said he flew over the handlebars, and I'm like either two dashes, that it's like falling off a motorcycle. You slam on the brakes and fly off. He said he hit the ribs, should be his ribs, but the ribs on the handlebar.
That doesn't sound to me like the same as being thrown up in the air, hitting the ceiling and coming back down. That sounds like a completely different explanation.
Well, when you fly over the handle,
Well,
and the
you fly
handle
over
where
the
it
handle.
is, that's what he said.
And you
So
hit your ribs, that doesn't indicate to me
hit
that
his-
you're being thrown
hit-
in the
hit-
air.
Hit his ribs on the way up. That's what he meant.
Very basically, what's the statutory violation here?
The statutory violation is that the prime mover did not function as intended by catapulting plaintiff. As Judge Fahey said, there are about 7 cases dealing with catapults, and the catapults are not just...
So what is it about the prime mover that was defective or inadequate?
Well, here's the thing. My adversary keeps referring to that, but when you look at the statute itself refers not just to defects, but to improper use, operation, or control. And if you read my brief, I believe the third department, has the more in line of cases which say that where you're dealing with improper operation, improper use, showing a physical defect is irrelevant. These are the latter cases. Every appellate division, every intermediate appellate division has held that you do not have to prove defectiveness when the ladder isn't secured, even in situations where the plaintiff set up the ladder by himself.
So what should be done with respect to a prime mover being used at a job site?
The prime mover should be used in a way that doesn't cause somebody on the back to be catapulted. Now, I agree that there are two potential problems. The plaintiff's testimony is, I was moving it, I was 4 to 6 feet away, I went down and I flew up. Defendant's position is, I believe, as Judge Tom said in the last part of his decision, was that the plaintiff was actually either loading it and loaded it too hard or actually stuck it. The fact is, since Rokovich, since Hames, since Zimmer, since Bland, comparative negligence is not a defense to a 240 sub 1 claim. Now, the problem is that it is very, very, very difficult to distinguish between comparative negligence and sole proximate cause.
So on the summary judgment, what was your argument about the safety device? Are you also in agreement that the safety device is the actual machinery?
No, our argument below was that there was no safety device to prevent the plaintiff from being catapulted off. Zero.
So what should have been there?
A cage?
Belt,
You could have had, well, the reason they didn't have it is obviously because nobody thought that this would happen. And that's, if you look at all the cases, Potter, Bilderback, Panorama, they're all the same. Nobody ever expects it to happen. But you could prevent this accident easily, just have a harness on it. Just nobody ever thinks it's going to happen. The fact of the matter is, though,
So
that
what was your burden of proof on that summary judgment related to this question about the safety device?
to show that the device did not function properly. And let me go to the O'Brien
The
case.
device here being the machine that he's riding?
Yes, the machine, as it was being operated, did not function as intended. And let me go to the O'Brien case. And Judge Fahey, you brought up
And
the fact.
as intended is to have the operator remain on the little platform, no matter what happens.
You bet. no one who's on a high-low, on a prime mover, on Bobcat, they're not supposed to fly off. No one can say that that's a permitted use of that
So this machine
instrumentality.
has that platform that also kicks up, right? And you can walk behind it like a lawnmower almost,
Yes, what you do is you
right?
fix the platform and then you use it like a lawnmower. That's
What
correct.
happens if he's walking behind it and he smashes his head for some reason? Same deal?
Well, not the same deal because you have a different fact. Now you might not have an elevation-related risk, but here there are multiple elevation-related risks caused by the fact that not only are you on an object that's capable of catapulting you, but you clearly, under runner, have an elevation-related risk because you are actually lifting a 1,500-pound load into an area that is actually fraught with danger. And I wanted to
But
bring...
I think the question is, what if he was walking behind the prime mover, lifting this load, and the same thing happened, only instead he fell forward and hit his head on the back of the
Well, I
prime
think
mover?
you'd have a different situation based on your decision in Rakovich. Rakovich basically says that not every elevation-related risk that you have falls within the
But
label.
here, that's the point, is that there are apparently some witnesses who actually saw what happened. And what we really have only is the testimony at this point of what the plaintiff now says happened and what the supervisor says he said happened. So don't we need to hear from these other witnesses to determine whether, in fact, this is a 240 case, an elevation-related case, to see what actually happened? Because to me, if he's standing on the back and he was propelled forward and hit his ribs on the handlebars or whatever they are, that's a completely different issue.
Yeah,
So
but-
why don't we need this discovery before we can say, as a matter of law, what caused this accident?
I can give you one factual reason and one legal reason. Let me give you the factual reason. It's as simple as the day. If you look at page 441 to 443 of the record, that's Mr. Catalano. That's the witness that they subpoenaed. They have his affidavit. So to say that you need discovery when you have the affidavit of a witness who's there really doesn't make any sense. The legal argument is
Well,
that...
sure it does, because he's not been subject to...
They prepared his affidavit.
I understand.
So,
I understand, but he's one of several witnesses.
Well, but the fact of the matter is that just because there's outstanding discovery doesn't mean that I have to wait on my summary judgment motion. And
Is there nothing?
as we,
Is there nothing the other witnesses could say that would change the result? That is,
I don't think so.
So
Because
if they said we saw him trying to pop a wheelie,
well, there's
I know there's no evidence of that, but that's because there's no evidence.
Right. There's no evidence. You have to show under the cases, and your cases are Chemical Bank against PIC Line and our back against Bennett. Not just that you have the right to conduct discovery, or even that discovery is outstanding, but that you made some effort and that you know what these witnesses are going to show.
You know, when they hear what the plaintiff has to say and who might be there, within 3 weeks they're serving subpoenas, but you've already beat them and gotten the partial summary judgment.
the action-
Excuse me, the automatic stay.
Your Honor, that's certainly true, except this action's been going on for 3 years. It's not like we didn't make, it's not like they didn't have the opportunity to do this right
why
away.
is this not controlled by Groves versus Land's End?
Because in this case, in Groves against Land's End, the First Department and this court said that there were differing versions of the accident. There are no differing versions of the accident here. There are none. If you look at...
Did
know.
they
We don't
argue
know what
that he
their,
wasn't on
these
top?
other
I
witnesses-
understand they're arguing, we don't know what happened. Did they argue that he was
I
not
didn't see-
actually using it and
No,
on the platform?
There is no testimony whatsoever. There's not a medical record. There isn't a contrary statement. There isn't even a hearsay statement that contradicts what the plaintiff said. Nothing. Zero. That's what he was supposed to be doing. In fact, Judge Stein and Judge Rivera, apropos to what you just asked, and Judge Feynman as well, let me read to you what Mr. Catalano said. This is the supervisor, the one who says that, the one whose affidavit they have. I'm reading it. Paragraph 8, 442. The pallet bricks weighed approximately 1,500 pounds, which was within the capacity of the prime mover. Indeed, we had moved and lifted similarly weighted pallets of bricks with the same prime mover for several weeks prior to August 5, 2011, without any problems being noted or communicated. There was no indication that the prime mover malfunctioned or that it had been overloaded at the time of the accident. This was a permitted use. This is what they did.
Does he say, I saw him standing on the
Well,
machine and
he
using
did.
it?
He clearly wasn't a witness, but he came there afterward. The part I read before came afterwards, so it wasn't like he wasn't injured. And I just wanted to say one thing. If you take a look at your cases, I think this breaks down very, very simply, and I'm not going to go over my time because I don't. There's a difference between comparative negligence and misuse, okay? And I actually figured it out, believe it or not, 7:42 this morning when I was walking by the Albany port trying to figure out the cases you were going to ask me. Here's the difference. If I'm driving a vehicle and I make a turn to come to Eagle Street and I hit a pedestrian, that's comparative negligence because I'm doing something that I should be doing with my car, but I'm doing it badly. If I miss the Eagle Street turn and I decide that I'm not going to go around, but I'm going to back up into that spot, that's a misuse. If you take a look at every one of your decisions, I checked every one from Hames to Felker to Gordon to Batista, which is mine, Weininger, Blake, it breaks down perfectly. If you're doing something that constitutes a misuse, that's sole proximate cause. My client could not have done that because he was doing definitionally what he was supposed to do and what Mr. Catalano said he was supposed to do at the time. I see my time is up. I'm going to sit down. Thank you.
Counsel?
Yes, just briefly. First, Mr. Catalano was not one of the eyewitnesses that we need to depose. He was admittedly on the roof or some other level at the time of the accident and also heard about it afterwards and came down after the accident occurred. The people we need to depose were the people that were at the scene, that were at the scaffold, whose names we only know as Mike, and the individual that was flagging the plaintiff.
How did you plan to find out who they were?
We need to take a subpoena on town masonry and get their payroll records to find out, who was at the scene. The records that we have from Plaza don't identify the particular individuals that were actually working at the scene.
Was there a reason you hadn't done that yet?
We had chosen to take the depositions first of Mr. Caratini and Mr. Catalano, who were the people that were identified. We had...
You didn't know the motion for summary judgment was going to be made?
No, because we had at least until December 6th of that year, and we're talking about June or July of that year, before the notice of issue was even required to be filed. And in New York County, those notice of issues can be extended if necessary, if there's good reason to do so.
So, counsel, I understand that you're arguing that you don't know whether or not he's negligent, used the machinery in a negligent manner. Did you take the position that he was not, in fact, elevated on this machine and using it? Was that the argument you made?
Well, that's what Justice Tom determined.
No, I'm asking you your argument, what you preserved.
I don't recall that issue being raised, whether or not the fact that the platform was only 8 inches off the ground. I think it was raised, but I don't have a firm recollection of it. But I just want to note that in terms of the distinction between negligence and sole proximate cause, here we have the plaintiff admitting in its brief on page 28 that the plaintiff operated the prime mover in a way that created the instability which propelled plaintiff over the handlebars. To me, that sounds that the prime mover itself wouldn't have been unstable except for the fact that the way plaintiff operated it. That's what the plaintiff is arguing before this court. That certainly raises the question of fact whether or not whatever he was doing goes to whether or not his negligence was a sole proximate cause or not. And because this whole issue is premature because of the need for the discovery, at least the eyewitnesses who actually saw what happened, we believe that the First Department's decision should be reversed and the case should be remanded back to the Supreme Court in New York County so that we can conduct the discovery that we needed and what we should have been able to conduct before this motion was made.
Thank you, counsel.
Thank you.